Now, I want to go across to senior advocate, Member of Parliament and chief spokesperson of the Congress Party, legal luminary, Dr. Abhishek Manu Singhvi, who's, of course, been publicly talking about these cases against Mr. Gandhi and this conviction, the fact that first the Sessions Court and now the High Court has refused to stay the conviction. Dr. Singhvi, thank you very much for joining us. You know, I was just discussing this in the debate earlier as well. The judge has opined in his order that one of the reasons for not staying the conviction of Mr. Gandhi is that he's taken into account that Rahul Gandhi faces another 10 criminal cases, including a criminal defamation case filed by the grandson of Veer Savarkar. The judge opines that this is needed to have purity in politics and that it's a well-settled principle of law that stay of conviction is not a rule but an exception. Was Mr. Rahul Gandhi seeking unto himself an exception and not a rule?
Okay, Zaka, you asked a longish question. I hope I remember all the components of that. Let me start by saying that as far as you are concerned, you are invisible on my screen.
Sure.
So I hope I am able to know that when you are hearing me or not.
I can hear you.
Now, as far as your point is concerned, there's a much larger issue in this judgment. But I'll come to that later. Let me answer your narrower points. Take, for example, Savarkar you mentioned. Did you know that Savarkar's complaint or the complaint regarding the Savarkar issue was filed 1 month after the present complaint had been decided finally in March? That was filed in April end. Did you also know that this is not part of the proceedings in the High Court at all? It was at the fag end on 2nd of May when the arguments were concluding that across the bar, a cutting was handed over, a method impermissible, no pleading, no nothing by the complainant. And today, astonishingly, when the judgment was pronounced at 10:30, ultimately the copy was given at 3 o'clock, the judge chose to mention this ground alone, which finds mention in para 63 of his judgment, which is not at all the subject matter of this complaint, which happened even as a complaint a month after the final conviction in this, and which was not argued. That's one answer. Two, because the learned judge, unfortunately, and I'm saying so again and again, it's a judgment riven with grievous errors, unsustainable errors. Because the learned judge is at pains to paint it as a very serious offense. If you see paras 43 and 45, you'll be astonished. In 45, the learned judge, perhaps unprecedentedly in the first time in the history of law in India, holds that a defamation offense of the maximum of 2 years is a moral turpitude offense. Moral turpitude is a term of art known to lawyers for centuries. It involves issues like rape, kidnapping, or other immoral offenses. It certainly has never been equated with defamation.
Okay.
Indeed, a 2-year maximum sentence offense can very rarely be called a moral turpitude offense. But that apart, where the learned judge gets that conclusion shows the direction and the trend from where the learned judge is coming, which is to paint it as very serious, because the previous paragraph uses the word serious 3 times, as if it's some kind of a rarest of rare murder offense. Then, again, take the example which you said about, this sentence, 1.5 sentences in a 3-page speech. The sentence names 3 persons by name, including Prime Minister Modi.
Yes.
The specific argument was twofold by our side, none of which is answered. None. The argument was that A, the term Modi is an undefined amorphous class. So there is no single community of Modis. There is no single subsect of Modis. There is no single group called Modi. Modi A and Modi B may be totally, racially, ethnically, origin-wise unrelated.
Okay.
So there is nothing which can be defined, which is not a defined class, was the first argument. Not answered, not dealt with. Second argument, more important, not even addressed. If, assuming even that it's a defined or non-amorphous class, which it is not, if there are 3 named persons and each of those 3 choose not to sue, choose not to show any personal loss or damage, can any member of this amorphous undefined class of approximately 13 crore people have standing and locus to get up and file a criminal complaint?
No, so Dr. Singhvi, the judge has, the judge has, if I may, the judge has observed in his order, and I'm quoting from this judgment, in the present case, in order to gauge the seriousness of the offence, another factor which compounds the case against the petitioner is that the defamation alleged was that of a large identifiable class and not just an individual. Due to the said fact, the conviction partakes the character of an offence affecting a large section of the public. So the judge is saying that by using the name Modi, he is offending an entire large identifiable class, not just an individual.
Raka, actually the learned judge turns the test on its head. The legal test is exactly the opposite of what you read. You're absolutely right. This is a grievous error. 3 points here. 1, there is material filed by us and argued showing the word Modi is not a defined class. A Modi in Punjab and a Modi in Gujarat and a Modi in UP and a Modi in Rajasthan has no connection at all. It's an undefined class. Second, that's not addressed. The learned judge assumes it to be a defined class. Second, where has the learned judge shown by a single judgment that a single Modi across, and by the way, all the Modis who seem to be aggrieved in this case, very, very important, are BJP Modis, BJP office bearers. This great outrageous reaction of the community is limited always to BJP office bearers. That, by the way, answers your other point also. All the 9 other cases repeatedly mentioned to mischaracterize Rahul Gandhi as a serial offender are cases where he's an accused, not a single convict, but each one of them is filed by BJP office bearers.
Okay.
So you orchestrate an across the country filing by BJP office bearers. Why? To stultify, emasculate and strangulate free speech and free thought. In a political campaign between A and B, a person speaks fearlessly, even if wrongly. It can never be criminal defamation. It's only because a orchestrated BJP campaign across the country by BJP office bearers, that does not give them standing.
Okay.
Mr. Prime Minister Modi doesn't choose to sue. Nirav Modi doesn't choose to sue. Lalit Modi doesn't choose to sue. On what principle has the judge cited in the entire judgment just said, does the person who has sued have standing? Only on the basis that an unconnected, undefined, amorphous community, Modi, any 1 out of 1,300 crore people, by the way, all of them being only BJP office bearers, can have standing to sue.
All right, Dr. Singhvi.
I mean, it's an amazing, ludicrous situation.
We'll have to leave it at that. I'm running out of time. Thank you very much for joining us, and thank you for putting that into perspective and your thoughts on what has happened today.